definition of native title is the recognition by Australian law that some Indigenous people have rights and interests to their land that come from their traditional laws and customs.
The foundational case for native title in Australia is Mabo v Queensland, No. 2 in 1992. 1 year after the recognition of the legal concept of native title in Mabo and Northern Territory, the Keating government formalised the recognition by legislation with the enactment by the Australian Parliament of the Native Title Act of 1993. The Act attempted to clarify the legal position of landholders and the processes to be followed for native title to be claimed, protected and recognised through the courts. The Federal Court of Australia meditates claims made by Aboriginal and Torres Strait Islanders peoples and makes native title determinations. Appeals against these determinations can be made to a full sitting of the Federal Court and to the High Court of Australia. The foundation case for native title in Australia is Mabo v Queensland in 1992. 1 year after the recognition of Aboriginal concept of native title in Mabo and Northern Territory, the Keating government formalised the recognition by legislation with the enactment by the Australian Parliament in the Native Title Act of 1993. The Act intended to clarify the legal position of landholders and the processes to be followed for native title to be claimed, protected and recognised through the courts. The Federal Court of Australia mediates claims made by Aboriginal and Torres Strait Islander peoples and makes native title determinations. Appeals against these determinations can be made to a full sitting in the Federal Court and then to the High Court of Australia. The National Native Title Tribunal, established under the Native Title Act of 1993, is the body that applies to the registration, tests, awarding native title claim applications, and undertakes future acts, mediation, and Aboriginal functions. Australia did not experience legislation involving Aboriginal native title until the 1970s, though several earlier cases tangentially involved issues of native title. In 1835, John Bartman purported to sign the Bartman's Treaty with Aboriginal elders in the Port Phillip district. Governor Bourke declared Bartman's Treaty was void and of no effect as against the rights of the Crown, and declared any person on vacant land of the Crown without authorisation from the Crown to be trespassing. The proclamation was approved by the Colonial Office. The official objection to the treaty was that the Batman had attempted to negotiate directly with the Aboriginal people, whom the British did not recognise as having any claim to any lands in Australia. In 1971, the Meltham v Navajo, the Gove Land Right case in Supreme Court of Northern Territory, Justice Richard Blackburn explicitly rejected the concept of native title, ruling against the claimants on a number of issues of law and fact, by rejecting the doctrine of Aboriginal title in favour of terra nullius, which held that the land belonged to no one at the time of British settlement.